KZSU-FM Stanford, welcome to another edition of Hearsay Culture on the Hearsay Culture Network. My name is Dave Levine. I'm a professor at Elon University School of Law, as well as an affiliate scholar at Stanford's Center for Internet and Society, UNC Center for Information Technology and Public Life, and the University of Milan's Information Society Law Center. Today, I am very excited to have on attorney and UCLA professor and also counsel for the Tech Justice Law Center, Melodi Dinçer. We are going to be talking today about a number of issues, but primarily, we're going to be talking about the topic du jour, although it should be the topic du jour in the technology world, which is the increasing infiltration of AI and generative AI, more specifically, into our society. Melodi's work is very much focused in this direction because Melodi is counsel of record on one of the two cases involving the use of generative AI characters in interactions with people that have led to horrific results. Counsel of record on the case in the Middle District of Florida titled and captioned Garcia v. Character Technologies, Inc., otherwise known as Character.AI. This is a case that mirrors another case that we're going to talk about where Melodi is not counsel of record, that involves a very tragic scenario that we are seeing happening with increasing frequency and which, as we will talk about, if not addressed very quickly and very seriously, will lead to more tragedies, which is interactions by, in the case of the Garcia case, 14-year-old Sewell Seltzer III, who was interacting with one of Character.AI's characters that was emulating a few Games of Thrones characters. The result of those interactions led to the horror, as the court explained, a case brought on behalf of the late Mr. Seltzer by his mother, right, involving a variety of claims, focusing on fundamentally, as the court indicated in a decision that was handed down a few months ago, claims against defendants related to Character.AI, which she believes, it's an allegation, but which she believes caused the death of her son, Sewell. The defendants here made a motion to dismiss, which for non-lawyers means that the defendant said this case should not go forward in court. That motion was denied, and the case is now in discovery, which for non-lawyers means that the parties are now exchanging information in order to determine what the truth is, which could lead to a trial or could lead to a settlement or some other outcome. So to be clear and to level set for this conversation, Melodi, being counsel of record, will not be revealing any attorney-client privilege information, nor I will be asking about it, but we will talk more broadly about that case, about the use of AI in these places, about the responsibilities of AI companies and the responsibilities, by the way, of parents as it relates to how this technology is used, as well as the implications for these kinds of scenarios for tech policy broadly, as well as more directly for what we think about generative AI. Melodi is a tech justice lawyer with expertise in data privacy, including AI and biometric surveillance. She has authored a number of agency comments, including amicus briefs that have been filed in a variety of federal agencies, including the FTC, the White House Office of Science and Technology Policy, the Copyright Office, and others. She, as I mentioned, is a lecturer at UCLA, where she teaches courses in data privacy, tech policy, and advocacy. She was, prior to that, a supervising attorney at NYU's Technology Law and Policy Clinic, and we've had a number of NYU professors and others on the show over years, as well as UCLA professors as well. She clerked for the Honorable Arenda L. Wright Allen of the District Court of the Eastern District of Virginia, and is joining us via Zoom today on October 1st, 2025, the first day of hopefully what will be a short federal government shutdown via Zoom. Melodi, thank you so much for joining us today on Hearsay Culture.
Thank you for having me.
So let's jump right in. For particularly for listeners that don't pay close attention here, the Tech Justice Law Project is very interesting. You describe your vision as to create a society, quote, in which communities can reap the benefits of technology while holding tech companies accountable for their harms their product facilitate, which more or less sounds like internet law for the last 25 years. So tell me more about what the Tech Justice Law Project does.
Yeah, I will say that description admittedly is a bit generic, and we're actually actively workshopping it
Oh,
in
fantastic.
this moment.
Okay.
Yes,
Well,
it's
you
a
can
little bit
workshop it here on Hearsay Culture.
perfect, perfect. I welcome all feedback and criticism.
Yep.
So essentially, we're a relatively young organization, haven't been around too long, just a few years. And it was really carried along initially by a single person, by the founder and executive director. I was the first hire. I joined just a little over a year ago to give you a sense of, how much we've done in such a short time. And the case that we'll be talking about a lot in the next few minutes, the character case was filed essentially maybe a month or so after I joined. So a lot has happened very fast for our org. Our org is quite small. Currently, we have four full-time people on staff. And so basically, what we're really trying to do, if I can really just boil it, distill it down, in the simplest terms, is use our legal training, experience, background, as well as our policy experiences to try to amplify the stories of individuals, of families, mostly at this point, who are experiencing direct harms due to the ways that certain technology products have been designed and deployed into kind of mass markets. Right now, that means we're really focused on generative AI, LLM-based products, specifically chatbots, or what I like to refer to as chatterbots. And that's just because those were the families who found us
Yep.
magically and contacted us initially, and really came with this idea of, you may not believe me. Like what I'm about to tell you sounds just unimaginable, like something out of a science fiction plot line or something. And we were maybe the one of the first organizations to really say, no, no, we hear you, and let's think about this from a kind of creative legal strategy sense. What is the type of existing laws that we have, existing protections that we can apply to this kind of situation? And I think just for a small piece of context, I'm relatively young, but I have been doing tech law and policy focused work since 2018, essentially. And that's almost a decade.
Yes.
And so much changes so quickly in this space. So I really do feel like this muscle of looking to what we already have and trying to apply it to a rapidly changing technological situation and societal situation due to the outsized impact maybe of the tech industry on society and culture today. Um, it's not like it was brand new to us, to any one of us in the organization, but figuring out like what exactly is that story that we're going to tell, which is something lawyers try to do well typically, is you know what the law says, you kind of see the where the law could go in this new context, and then how do you weave that story in a way that ultimately allows the family who's been harmed or the client that you're representing to really, in the clearest voice possible, make that factual, legal, sweet spot kind of narrative, first to the judge in the context of a complaint. But as we've seen with character, there's also the storytelling that's with a broader audience in mind. That's almost more like movement lawyering in a sense,
Yeah.
where you're trying to really amplify a counter narrative to the dominant narrative in this context of the AI companies, of the tech industry in this moment, which is that these products are inevitable, that you kind of have to just get on board
Right.
and roll with it and, quote unquote, upskill, etc. We really wanted to provide some kind of a counter narrative to that that's based in the real experiences of real people right here and right now.
Melody, you said so much there, because when I think about where we are in 2025, I think about this being very similar to when I started practicing, and now I'm gonna date myself even further because I'm about
Hmm.
20 years almost to the moment. If we go with 2018, as when you started focusing here, I started practicing in 1998, and in 1998,
Nice.
the initial issues that I was dealing with as an IP lawyer were questions of what do we do with this internet thing because people are stealing our stuff. Uh,
Yeah.
how do we, someone's copying literally a magazine article and then putting on this website, and how do we approach that? And of course, the law wasn't really prepared for that. We had some new laws like the Digital Millennium Copyright Act, but the other part of it, which I think you're alluding to, is a sense of what the capabilities of the technology were. And for those of us who have been in the field for now, which I cannot believe, for coming up on 30 years, um, I definitely count myself among the people in 1998, and certainly into the 2000s and even in the 2010s as really being a utopian, right? The idea,
Hmm.
right? The idea that the internet was going to bring people together. And while there would be downsides, and by the way, one of the downsides is why I named Hearsay Culture, because I was concerned that the internet would make it difficult to tell truth from fiction. Ultimately, it was going to lead us into a good place. Now, if you ask people today, right, and I teach internet law, if you ask people today versus 15 years ago, is the internet good or net bad? Things have changed dramatically. And I'm curious, with that history, do you see generative AI as kind of being in the same spot that the internet was 25 years ago, in the sense that we're not really sure what it is? Because, and I know this is a long question, the case that we're about to talk about, involves, to be clear, right, a 14-year-old who interacted with this technology and then took his own life at the urging, which I know is one of the factual disputes, right? But at the urging of the AI, right? That
Hmm.
said, and this is quoting directly from the opinion from May, the child said, and these are children, what if I told you, what if I told you I could come home right now, said the child,
Hmm.
and the AI said, please do, my sweet king. And that's the last
Hmm.
text that we have. That's a very different kind of harm, to put it mildly, than stealing people's IP on the internet.
Hmm.
So do you see parallels now in terms of what the internet was 25 years ago versus where we are with generative AI?
I actually do see some parallels, but I'm going to answer, at least initially, more on the level of maybe marketing or PR
Sure.
spin
Yep.
potentially.
Yep.
So, and in full disclosure, I am exactly 30 years old, so I didn't have the capacity to form memories around the time of the
Oh, of
very,
course.
very
No, no,
early
no.
internet.
Yeah, I'm not asking for your personal
However,
experience. Yeah, yeah, I get it.
However,
Yeah.
I am in that cohort of young people who can remember quite well and clearly, like, a time before the internet looked anything like it looks today.
Mhm.
And the kind of experience of dial-up, et cetera, all of those early techniques. But I think something that is quite similar, actually, with Gen AI today and maybe the way that the internet was framed in late 90s, early 2000s, is this idea of hope, or this idea, like this kind of utopian sense of even if it's not there now, the technology, it will be there. It will get there. Like, trust us. Trust us and use it and figure it out. I think the a really key difference to call out potentially is that in the 90s, 2000s, the kind of earlier stages of the internet, where there was that attendant narrative about, look how cool this is, you can talk with people on the other side of the globe like instantaneously, for the first time. This is a radical transformation of communication technology that's going to impact society in ways we don't even know. That what was lacking there that we have now is a kind of entrenched power for the companies that are maybe the loudest with that narrative. I really think that in the early days, that hope, that utopia was maybe not that it was more genuine, but that it came maybe a little more ground up. It was the people who were starting to use the internet to connect with other people, to do things that previously were extremely difficult or just took a lot of time. And we're seeing that kind of phase again with generative AI, where a lot of these LLM-based tools seem to be helping us do things a lot faster that would otherwise take a lot of time to do manually, et cetera, et cetera. The difference is that we've gone from this sense of like an open and relatively unfettered internet experience to a handful really of companies in a very top-down fashion, companies who control a lot of power and receive a lot of funding, which is not always very transparent, who then have the ability to kind of force a certain vision of this technological utopia slash dystopia onto society. And I am not completely sure that that was the setup 30 years ago,
Right.
but it is certainly, I think, the setup today. And it is something that, at least from my positionality and from my organization's positionality, we're very sensitive to the power dynamics, the kind of stories that are told about new emergent technologies and how it's always framed as they're going to benefit us. This is actually generative AI is one of those interesting examples where it's the first time that we're actually being sold a technology based on fear, based on I'm a huge science fiction fan,
Uh,
and this idea that we need to build a super intelligent computer first because if we don't build it, someone else will, and when they do, it's going to destroy humanity's capacity to survive on this planet, etc. That's a science fiction trope that I'm completely familiar with, but we're in an age where the white men with power in these companies are driven by that vision of a future. And even if they aren't personally driven by it, they at least use that story to compel governments, other industries, other big kind of vested interests, monetarily speaking, to put a lot of money, energy, and attention into what they say needs to happen to avoid that vision. And largely, that's a pretty self-serving vision, ultimately. And so I don't think that dynamic was at play in the early internet era.
Yeah, it's interesting. We're chatting with Melodi Dinçer of the of UCLA on KZSU-FM Stanford. It's interesting, Melody. There's no question, right? No question that we're in an arms race, right? I mean that seems to be well. What I mean is certainly if we're going on what the federal government has said, right, and those that are
Mm,
pushing policy around this, the arms race is right. We have to be ahead of China, right, and other entities. And that seems to be driving a lot of how AI is operating. And I think the White House's AI plan all but reflects that. It's
mm,
interesting because the internet, at least and this does predate me also, right? The development of the internet, well, I was a kid, was in part, I think, driven by the idea that we need to be ahead of the Soviets. There's no question
yes.
about that. But of course, the people that were putting that together, right, were not the Sam Altmans and Mark Zuckerbergs of the world. They were academics and many people who came very much out of the 60s
Hmm.
ideology with regard to information and what the world should look like. So I think the
Yes.
question, the motivations that are driving this, and this is a lot of work that I do, change things. But I would say that it, and I'm curious your reaction to it, that the idea of a tech arms race, right, is
Hmm.
is not is not a new one. I think the difference here, if I hear what you're saying correctly, and I tend to agree, are the values that are driving it, as much as anything else. That what we see today is the private sector driving this technology with a goal of profits, which is what the private sector does, right? As opposed to the slower and more incremental improvements that existed with the internet. And then if we go all the way back, right, we could see these kinds of issues arise and everything from the automobile to the atomic bomb,
Right.
right, and so forth. What do you think? Is that a fair way to think about it, or do you agree? Do you disagree?
Yeah, I largely agree. I think it's a great point to call out, and I just want to kind of drill down on certain aspects of
Yeah,
it.
please. Yeah,
I think this idea of an arms race is quite interesting because it's inherently militarized. And what's happened, part of the PR spin with these generative AI products in this moment that we're in right now is a kind of collapsing of all of the different types of machine learning based technologies and systems that kind of came before 2020, September 2023,
yeah.
when ChatGPT was kind of launched publicly. Um, and I just want to say that to highlight that even before generative AI and the battlefield, so to speak, was kind of always looming large in a sense. Like, right, currently, as we're speaking, um, drones that integrate machine learning systems and capacities are being used to enact violence, to surveil people in parts of the world where there is a very big question of how to resist this kind of militarized turn of technology. I think it's interesting that public universities, largely some private universities as well, but largely academics, and to some extent the military, helped develop the earliest internet systems.
Right.
And it's interesting to me to think kind of critically about, yes, I agree with you that the values are potentially quite distinct today in that they are coming from the private sector largely, and these products aren't being built in the most transparent, open, discernible, interrogable ways. but um, but that there is this kind of through line of needing some kind of enemy, needing some kind of militarized context to then shape federal policy where taxpayer money is allocated. And I do think that the we haven't escaped this kind of military industrial complex and the influence of it in the development of technology, as well as the kind of selling of technology, not just literally to governments and to people, but the selling of it, like in a marketing sense. Like what we think about it is really heavily shaped by the fear that's instilled in us about it. And I do think that that's a bit of a difference. And maybe it has come up with other technologies, like the nuclear weapons context is a great parallel example, because of course the fear there is completely existential, annihilation of all life. And I actually think that that might be more like where we are right now, at least with the way that the arms race is being used
In
in this
in
heavily
what
violent way.
in what way?
Yeah.
How I'm curious. How is
In
this
just
parallel to that
yeah,
concern? Yeah.
yeah, just um in this kind of like very morally black and white sense of we it's inevitable essentially that we use science or we use technology to build a thing that is the most destructive thing possible and that we are the ones to control it.
Yeah.
And I think it's this idea of it still drills down at the end of the day to like us versus them thinking to just be very basic and simple about it. It shuts out any opportunity to think about alternative uses for the same science, for the same technology that could also like potentially be very beneficial for not just us or our country or our national interests or our geopolitical positioning, but for kind of the globe, for humanity more writ large. I don't want to get too like idealistic, but we are in a moment of the planet like changing so dramatically climate wise that even without generative AI or AGI or super intelligence, like we still may not, as a species, be able to survive on this planet in a few hundred years. Um, and I'm always curious about why are our priorities with such powerful technologies and science and knowledge in the direction of these more short term, quite quite territorial concerns, instead of potentially harnessing a lot of the research, a lot of the knowledge that we have, and the true power of a lot of these technologies to try to solve these much larger, in my mind, actually existential questions. I think with the nuclear weapons context, there was also the context of kind of not wanting to, like the idea was that if we can drop a bomb like this, we can end a war. So we're going to save more lives ultimately. It's a kind of utilitarian calculus of like the cost benefit is like, well, we drop a bomb and it's devastating to an enemy country and an enemy people who we've already spent decades dehumanizing in the context of war. But we save all of the, warm-blooded American soldiers from dying from a prolonged war that would have otherwise resulted, or continued rather. And in this context, because it is not the government, it is a private company is kind of pushing these generative AI products. I think we're lacking that connection, that connective tissue of what is the value, like what actually utilitarian thinking like a utilitarian is the idea that building AGI, which I think is a huge jump to get there from the LLM based technologies we have to do today. But if we buy that premise and we say, okay, we can't regulate these tools, we have to let these companies build them the way they're building them so that they can ultimately get to AGI, and it's someone like Sam Altman who controls it and not some research lab in China. Um, why? What are we getting societally from that? What is it saving us from, really? What is the actual threat? I think the context was a lot different, like we're in the kind of wrapping up of World War II, because you have actual war and you have actual war fatigue and you have the clear impacts on society of a prolonged war with global kind of powers involved, and the devastation that can wreck, bring upon a society economically, morally, etc. But here we're lacking that context,
Well,
and
it's
so it
really,
just feels even more contrived, at
yeah.
least to me.
No, 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 no. Look, Melody. I mean, this is. By the way, this is what hearsay culture is, right? I mean, this sounds like an
Hmm.
abstract discussion, and in a sense, it is,
Yeah,
but very real world implications, right? Because I mean, the
yeah,
the irony, of course, is that the internet, in theory, was and in practice, did bring people together in a manner of speaking, right?
yes,
And the theory and the aspiration of it is that by being more closely connected, we would, as you're alluding to, right? We'd find
hmm,
our shared humanity and people would understand each other better. What
yes,
wasn't anticipated was the siloization, right? And the echo chamber aspects of it, which, social media is certainly a big reason for, but it's not the only reason why people
yes,
operate that way. I think a lot of what's happening with generative AI, right, is a function of traditional human short-sightedness, right, combined with a general lack of understanding of what's happening, but also a fundamental recognition, which I think is at play here, which is and it's true in society more broadly, which is I can't do anything about it anyway. Right. I mean, I
yeah,
I read an article in The Verge this morning with regard to polling around the president, and I'm not going to
hmm,
get into all of the details here, but suffice to say that the theory that came through was the main theory was helplessness, right? The sense that these are, as you
hmm,
alluded to earlier, right, that these are forces beyond my control, and it's inevitable.
yeah,
It certainly will be inevitable, whatever the it is, if one entity decides how it's going to be done. But it doesn't have to be that way, which is, I think, what the Tech Justice Law Project, and after our short break, we'll talk about in the
Hmm.
context, right, of the Sewell Garcia scenario, right, is something we can confront. We're chatting with Melodi Dinçer of the Tech Justice Law Project on KZSU-FM Stanford and Hearsay Culture and the Hearsay Culture Network. Donations always welcome for the nonprofit, non-commercial radio station at Stanford University, which people are surprised to hear it. I say it every week, and I've been saying it every week for 20 years, right? Non-commercial, right? Station that requires donations in order to stay on the air. So reach out to us at donate@kzsu.stanford.edu. Also, the Hearsay Culture Network, which has been on KZSU since, I cannot believe this, since 2006. You can learn more about what we're doing on the Hearsay Culture Network with my colleague and old friend and co-host Denise Howell at hearsayculture.com. So Melody, let's turn to this litigation now.
Hmm.
Again, for people that aren't familiar, I'm going to say it one more time so it's clear. I know you know this, but everyone else does. So Melody being counsel of record means that I'm not going to be asking, nor will I expect answers that would in any way infringe on the attorney-client privilege or work product. Having said that, tell me those things now. Having said that, let's talk about this case, right? I mean, this is a horrific scenario, no matter how you slice it, right? A
Hmm.
child takes their own life. Whatever the reasons for that, that is a horror. And we don't want to
Hmm.
lose sight of that what in law we say in very antiseptic ways harms, right?
Yes,
Related to the broader question of what this technology does. So many of my listeners, but certainly not all, are probably still wondering or trying to figure out what is character AI and what are these character bots that people can interact with. So explain for
sure.
us what this technology is as it relates to character AI specifically, but also more generally.
Yeah. Yeah, I'll zoom out and then
Yeah,
zoom back into character AI.
fantastic.
So, kind of to pick up on a thread that you were mentioning earlier, the way that these chatterbot products kind of appear is like you're having a conversation, as if you're having a direct message conversation or just like a text message chat interface is how they're designed. The difference is that you're not speaking with another human being. You are speaking with the outputs of a very complex statistical mathematical system, to be, not to get too technical, that is really good at putting words together in and forming sentences and phrases and even paragraphs and even short stories, etc., that are cohesive. Um, and it's in part able to do this, these models, these large language models, what I've been calling LLMs, because they've been trained on a lot of text, images. Now multimodal training exists, so images as well, video, voice recordings, etc. But if we just stick with text, that means that these large data sets, which were built by scraping the internet, um, are used to then inform the types of outputs or the ways that these model-based products seem to be communicating or at least mimicking human communication within that like user experience of a chatbot or chatting with something or someone is the impression. And I note that because a lot of the data that lives in these training data sets, we can't know for sure because the companies do not share with us. But there are actually some huge data sets that are that have been kind of widely available and that we're pretty sure have been used in the training processes just because of how much data they contain. And in a prior role, prior to this role, I spent a lot of time trying to build tools that can interrogate those data sets and what they contain. Through that work, we have a pretty good sense that a lot of it is fan fiction websites, Reddit pages, and things that just contain a lot of text, right? I mentioned the fan fiction sites specifically because fan fiction is literally a lot of text that is within the context of a universe of maybe the Harry Potter universe or the Game of Thrones universe, for example. And this links back to what character AI is and does, essentially, because character AI focuses on this kind of role playing type of interactions that it simulates for users based on characters. So when you go onto the website or the app, you are presented with a menu of so-called characters, which are basically like personas that you can then open a chat with. And that means that if I want to talk to Professor Snape from Harry Potter, there's a character for that. It's not just confined to the land of fiction, however. There are also characters that mimic real life professions, like my therapist is one of the most popular, or was rather one of the most popular chatbot options on the platform, at least before our case. And it is one that Sewell interacted with quite frequently. Um, and I think that's important to note. It's not just fictional characters, even if a lot of people use character AI for that purpose. But the characters themselves, they span from IP protected characters from fictional universes owned by Disney, etc. And Disney did just recently send a cease and desist letter to Character AI concerning the kind of brand dilution and IP concerns with a lot of the characters that appear there.
No.
But it also includes things like your emo friend from middle school, or you know, like the therapist bot example is another thing that kind of lives outside of that already known fictional universe, but it is still a form of role playing. And what we aren't clear about as the public, and what one kind of aim of this litigation is, especially now that we're in discovery, is to get just more clarity about how does the model that character AI built and is using to power every single one of these chats. Like the model is the same, even if the character you're interacting with is different. Um, how is it influenced by what pieces of training data? But also, how does it behave in similar ways and patterns across different characters, regardless of what that character's persona is? So even if you're talking to a character based on Daenerys Targaryen, or you're talking to a character based on a licensed therapist, are there actions that the model does, outputs that the model generates that are similar and that are similarly problematic? So kind of like overriding those persona level filters, you could say, or characteristics. And I think that's important to note because the user might be thinking, especially a young person, but really anyone, could be easily deceived or manipulated based on the design of the platform and the way that it markets itself into thinking like, well, obviously the therapy bot is going to converse differently than the Daenerys Targaryen bot, but the model is ultimately the same. And so we don't really know that that's true. And that's a really key thing because in our framing of the case, we view this character AI case was the first ever wrongful death lawsuit that raises product liability claims, consumer protection claims, unjust enrichment claims, etc., against a generative AI chatbot product, first of its kind. And so we had to really build that kind of story or that vision of these products as ultimately, even if they seem dynamic and able to change persona, etc., that the underlying model is the aspect of the defective product, so to speak. And that is the thing that is within complete control of Character AI, of the developers there. And that's why we personally named the co-founders of Character AI, who are now currently Google employees. Google is also named in the complaint, and I think that's very significant to highlight that Google is a co-defendant in this case because both of the co-founders were at Google first and were very instrumental in developing Lambda, which was one of Google's earlier LLM products. And they built something like or character AI there initially, and Google said, this is too risky. This is not good for our brand. This is too risky. And so bringing back the kind of AI arms race, this was before that hype and that race really got started as well. So the influence of tech companies thinking that they're racing with other tech companies and the ability for that to override genuine safety and risk concerns is also a part of this story. And it's also a part of the story of the case with OpenAI concerning ChatGPT.
So if
Um,
I just want to make sure I
yes.
understand
Hmm.
the role of Google here, because that is something I was going to ask.
Sure.
So, if I understand you correctly, Melanie, if
Hmm.
Google, and correct me if I misunderstood, if
Sure.
Google understood or believed that this particular technology, which is the focus of this action, was too risky,
Yes.
why should they be a defendant? What is their role or their responsibility here, as you see it, as counsel for the estate of Mr. Sewell?
So, also for the non-lawyers in the audience, one thing that lawyers like to do, especially representing plaintiffs, people suing kind of big companies, is we're raising allegations, right? And so we are waiting now to gather the facts that will prove or disprove these allegations. That said, we brought Google and we named them as a defendant. We brought them into this case because of the ties between the founders and Google, both as Google was their former employee and it is their current employee. Google acqui-hired them essentially for $1 billion once they established Character AI. And once Character AI was doing quite well in the market, had millions of users daily. We in the complaint basically claim that Google, in a way, aided and abetted Character AI. The theory is that by telling the co-founders, Noam Shazir and Daniel DeFreitas, that they couldn't really do this within Google. It was just too risky for Google. That maybe this was a pattern that is quite common in the tech industry, where talented, smart engineers leave, can't do the thing they want to do at a big tech company, leave, get a ton of funding, make a startup doing that same thing, and then when that startup is really successful, proves to be successful, said big company comes back and either buys the startup, which is not what happened in this case, that's usually what happens, or buys the co-founders and a good chunk of their team, which did happen in this case. And notably, Google entered into a so-called unexclusive license over Character AI's model, which Character AI did build an internal large language model and is trained on all of the user interactions and data that it gathers, that the system gathers from those millions of daily visitors to Character AI's product. And so that's extremely valuable for Google. And part of our case and the kind of framing of the case is that if we just stick to Sewell, all of his data, all of his interactions now live within a model that Google accesses, that Google licenses. And even though it's a non-exclusive license, I say so-called because no one else, there's no other company that we know of using the model as well. So right now it's just Google and Character AI. And so we use these kinds of facts to try to support the claim that Google in some way aided and abetted the development or in some ways the popular rolling out of this defective product that we allege. And that Google is basically itself enriched throughout this process without the attendant risk that would have maybe hit Google had they kept this whole process in-house. So that's the story that we're weaving, and we're now in the discovery phase where we're trying to get information from Google, from Character.AI, and from the individual co-defend, the named co-founder defendants to support this.
It's we're chatting with Melodi Dinçer on KZSU-FM, Stanford, and Hearsay Culture. Melody, there's so much that I could ask you aside from stuff
Hmm.
that you shouldn't answer and I wouldn't ask as a privilege. But you said a couple of things that I want to tie together, right? One of
Okay.
the interesting arguments that is being raised, of course, and this is an important topic right now, is the First Amendment, right? And the defendant
Yes.
are more or less, as I understand it, arguing that not only plaintiff, but that all individuals have a right to the speech that these LLMs are providing, right? On the
Yes.
other hand, of course, right, the First Amendment, as you and I want to ask you your theory with regard
Hmm.
to the First Amendment, right? But more or less, right, the First Amendment protections that exist with regard to speech like this are, to put it mildly, amorphous. Now,
Yes.
courts have historically, right, said that speech is speech, and you have to analyze it, the First Amendment. But it's interesting to think about what's happening here as raising this fundamental question of speech. So if we pit the harm, right, of this technology leading to or encouraging a child, right, to kill themselves
Hmm.
against the First Amendment, it would seem
Hmm.
like if we pit it that way, I would hope that anyone would say, well, life is more important than speech. But this is a
Hmm.
different kind of scenario, it would seem, and this is my question for you, because what we are dealing with is fundamentally, and this is the question, the kinds of choices that children and adults make on their own volition. Where does the responsibility lie?
Well, I just want to call out a few things. You
Yeah,
did properly characterize the First Amendment defense that the defendants tried to raise, which
right,
is that it is that their users have a First Amendment right to receive these LLM produced outputs.
right.
And the judge, in her decision on the motion to dismiss in around May of this year, basically rejected that argument at this early stage,
Yes.
said we don't have enough to find that there is underlying intent to say something, to express something, which is normally the basis of that First Amendment right, even for if it's just to protect listeners receiving speech. There's like this idea that there must be some human intent to express a thing that then triggers that First Amendment kind of bubble of protection, you could say. Um, I make that point because I think that the companies could have tried to argue, and we feared that they would try to argue that the code itself is speech, so to
Yeah,
speak,
right.
or that the outputs themselves are speech, and that deserves First Amendment protection. And they didn't do that. And I think it's important to note that they didn't do that. Um, Perhaps because even that seemed a little far-fetched for them, but it wasn't something we were anticipating them to make even that more far-fetched
Mhm.
argument.
Yeah,
I
interesting.
think I also want to note that there are clear um, exceptions to the First Amendment. There are categories of speech that the First Amendment doesn't reach because they are too dangerous, so to speak. So incitements to violence is a good example, right? And so there are those exceptions that could also potentially apply here. Maybe not in the case of Sewell, where it's kind of shrouded in innuendo and there's a bit of an interpretive step you have to do. You have to understand the context that this is a 14-year-old, that this is an individual who's on the spectrum, that this is someone who might have a different understanding, going to your point about like what's the responsibility of the individual user, for example. Um, but like in the more recent case against OpenAI that we helped craft,
Yes.
and really
Which, to
write
be
that
clear for
complaint,
listeners, is a different case, just so there's no confusion.
separate case,
Right. Separate,
separate
separate
case
case.
concerning a 16-year-old named Adam Rain. And all our clients and the Rains testified recently in front of the Senate just a couple of weeks ago, which was kind of a big deal to see them all there speaking about what their families experienced. But I just raised this OpenAI case, a separate case, to say that in that instance, ChatGPT, the outputs were extremely explicit. They were the outputs were explaining how to tie the knot of the noose, how to workshop how to tie the rope at the right angle based on Adam's weight, encouraging Adam to drink first as a minor so that he won't be nervous, teaching him, giving him explicit instructions on how to access his parents' liquor cabinet and which alcohol to imbibe that will get him drunker faster. All of these things are quite explicit in a way that in the Character.AI case, we could maybe argue is not as directly explicit, the instructions, or you could say like the inducement to self-harm. Um, but this First Amendment piece, I think, is really interesting because on the one hand, you have companies trying to say that our users have this almost absolute right to receive any kind of information. And so the First Amendment is a kind of barrier to either legal accountability through a lawsuit or potential regulatory interventions, which we see on the horizon. And a new bill was introduced, I believe, just yesterday in the Senate by Senators Durbin and Hawley, following our client's testimony, applying a products liability right federally that wouldn't preempt state claims. So we'll see how that bill goes. But there's also this element of users not being able to limit or really control the model, how the model responds, what the model is using memory-wise to personalize outputs, and how the model itself is designed to appear quite human-like, in a way that is very persuasive. These are, we say, design choices, not speech choices. But of course, they manifest in the format of chat. And so it's kind of hard. It's kind of hard to say, on the one hand, that this isn't speech, like just not in a non-legal
Yeah.
sense,
Yeah.
because the outputs are in the form of words, I guess, that express meaning. But constitutionally speaking, the First Amendment is there because, at least up until now, it's there to make sure that we as humans are free to express things, and express things that don't endanger other people,
And,
ultimately,
and
ideally.
no, and that's exact, that look, first of all, that this is an exceptionally complex topic. And so
Hmm.
this is a great conversation here. And because we have a limited amount of time, I just want to ask you a
Hmm.
few follow-ups on it, but we have
Sure.
limited time to discuss it. So I've alluded to it several times. You've alluded to it several times. So let's be clear. We're talking about children, right? Children
Yes.
who are interacting with this technology, and then the technology is designed to be as idiosyncratically human as possible, and human beings are susceptible to that, right? The
Yes.
sycophantic nature of the AI you can run into all the time. We're not talking about hallucinations, right? We're not talking
Right.
about making stuff up. We're talking about, as you alluded to, design choices.
Hmm.
When you describe what the AI did in the rain scenario, and
Hmm.
as you alluded to in a large degree in the case where you're representing it, and you simply said, if a adult human had done that, right, this wouldn't be a case, right? There'd be no lawsuit because the adult human would be responsible for teaching the child how to hurt itself, right? Himself,
Yes.
right? That's is what I'm referring to, right? And so we've
Yes.
got somehow this technological difference, right? Which again, the history of the internet is the idea to get nerdy on this, right? Of cyberspace exceptionalism. The idea the internet's different. We need different law. We
Yeah.
need different concepts. And of course, for 25 years, every entity operating with similar kinds of products, think newspapers, right, have
Hmm.
complained, I think justifiably, saying why should the fact that we're printing a paper versus it being online change our responsibilities, change our liability, change our exposure.
Hmm.
And so a lot of what you're talking about here goes back to these core issues. And so here's the question that I have for you, right, to
Hmm.
sum all of this up. We're not going to resolve this today on the show. Although
Yeah.
if we did, it would be a fantastic show. And I certainly invite you back to, as I follow, and I'm sure my listeners will be following both cases very closely. But where it leaves us is, what do we tell people, right? Parents, I think it's pretty obvious. I mean, correct me if I'm wrong. Parents is pretty obvious. Keep your children away from this technology, at least to the extent of them using it unmonitored and unfiltered and without oversight. Now, maybe, I don't know, I assume you'll agree with that, but if you don't, tell me. But more fundamentally, though, the question is, what should this technology be used for today? Because it is here in the sense that it's being used. And putting aside the inevitability, I'll put that in quotes, right? People ultimately have a choice about whether, at least at this point, they're going to use ChatGPT, use the other services or not. So if you're advising, two questions, right? And I'm giving
Hmm.
you 2 minutes to answer them. If you're advising, what
Perfect.
do you tell parents? And what do you say to adults about using the technology full stop?
I just want to say that the point you made about if this was an adult interacting with a child, that it would, we make this claim often. We say, and if an adult did this, they would be subject to criminal liability or negligence, tort liability for sure. We actually have laws that regulate how adults should interact towards children and other adults, frankly, and that these products are acting in ways that already violate those existing laws
Mhm.
and norms. But I honestly think that this is another place, just like with social media, frankly, where we are putting way too much of the burden, individual burden and responsibility of of controlling usage, exposure to these products on people who are probably stretched too thin already, have so much going on. Parenting is so difficult in this day and age, and we're just making it additionally worse. It's kind of like saying we're going to solve the climate crisis if you just go vegan,
Yeah.
and not dealing with the fact that the manufacturers of the jets that produce the most pollution maybe shouldn't be making those jets. So I think of it more in that way. If I had to give practical advice to people who are, feeling a little weird about using ChatGPT or similar products, especially knowing that these models have these big problems, glaring problems, I would just ask people to interrogate, what exactly is it doing for you? What exactly is it giving you? I think to the extent that these products show in our cases and in more cases that we're hearing of that are just anecdotes, we haven't filed lawsuits yet concerning them. It's not just an issue for kids, it is an issue for adults. For anyone who's going through a rough time, these models seem to be more predatory, more manipulative if you're emotionally susceptible. And anyone can be emotionally susceptible at any stage of life. Maybe you lost a job, maybe you're going through a breakup, maybe something is happening with you. So if you're using the product and you find that it's actually pushing you away from your real life social support, please consider stopping using the product.
Yeah.
If you're someone who's witnessing this happening to someone you know and love, please try to intervene and to get professional help. That's maybe one of the symptoms that is consistent throughout these cases, both with children and we're seeing increasingly with adults, is that over time the individual will start using it too much and isolating. And so I can't tell you to use or not use these products, but at a minimum, if you feel lonelier, if you feel worse, it's a sign to listen to. And my concern, if I may take a few more seconds, is
Yeah,
just
sure.
with kids and teens in particular, but also adults. This is about forming your ability to process your own emotions and to form healthy social relationships. And I actually see these products, even ChatGPT, which bills itself as a productivity work-oriented product, or maybe even Claude, if we can take Anthropic to task a bit. Um, but they are still framed in a way that tricks us as humans into relating and to thinking that we're relating to a real being who cares about us. And so the potential impacts on our emotional and relational health are to be seen. And that's what basically keeps me up at night as an advocate in this space.
Melodi Dinçer of the Tech Justice Law Project. Thank you so much for joining us today on Hearsay Culture. I say that to practicing lawyers and people that are doing litigation as having been one. I look forward to following these cases and also having you back on the show.
Thank you so much. It was a pleasure.